Hi everybody, my name is Michael Christie. I am a patent and trademarks attorney, and today I'm going to talk to you about intellectual property. So we'll discuss what IP is, the different forms of intellectual property that exist, and how intellectual property can be protected. We'll also discuss why it's important to protect intellectual property when commercializing a technology, particularly in the biotechnology field. And I also want to discuss some of the strategies associated with protecting intellectual property, some of the strategies that might be relevant to your own circumstances. Okay, so the format of today's talk is on the slide. We're going to briefly chat about intellectual property in broad terms, what intellectual property is. Then we'll focus on three different types of IP protection, those being trademarks, plant breeders' rights, and patents. We'll cover trademarks and plant breeders' rights fairly quickly and focus mostly on patents because I suspect that's going to be relevant to all of you. Okay, so what is intellectual property? Intellectual property, it's hard to define, but it has been described as a creation of the mind. So intellectual property can be something as simple as a small scribble on a piece of paper, a few words of writing, right the way through to a complex invention, like a therapeutic for a new disease. These are all products of the mind, and many of them can be formally registered as intellectual property, others not. The asterisks there indicate forms of IP that are not formally registerable. Copyright exists upon its creation. When you write a novel, you automatically have copyright in that writing. Know-how and trade secrets, they're forms of intellectual property that exist, provided you maintain confidentiality. The types of IP that we're going to talk about today are registerable forms of intellectual property, so trademarks, patents, and plant varieties. So starting off with trademarks. Now, I'm sure you're all very familiar with trademarks. You come across them every day, but they are actually perhaps broader than you might think. A trademark can be a single word, it can be a collection of words, it can be a logo. It can be something like a color even. So the color purple associated with Cadbury chocolates is a trademark. It can be a sound, it can be a smell, it can be any one of a number of things. But the main purpose of a trademark is to act as a badge of origin. So trademarks are not intended to describe a particular product, but rather to indicate where that product comes from. So these are some trademarks that you're probably very familiar with. The McDonald's Golden Arches, the Apple symbol, the words Spirit of Australia, which is Qantas. All of these are different forms of trademarks. And hopefully what you can see by this is that trademarks are not trivial objects. They are, or they can be, extremely valuable. Take the Nike swoosh. If you put that on a t-shirt, well, first of all, you know where that t-shirt comes from. You know that it's a Nike t-shirt, so that the trademark is serving its purpose as a badge of origin. But also, you associate it with a particular quality, and that's sort of the value of a trademark. If you can build a brand around it, the Apple is another good example. If you see that on the back of a computer, you associate that with a particular level of quality. You know where it comes from. You probably associate it with a particular price tag as well. But that's the value of a trademark. When I see the Broncos symbol, I associate that with the best NRL team in the world, being a Queenslander. Now, what does it take to register a trademark? You'll see that there's trademarks which have a TM beside them, or that have an R with a circle around them. This R here. This R means that it's a registered trademark. Now, to be a registered trademark, the mark has to be inherently adapted to distinguish. Otherwise, evidence of secondary meaning to reuse is required. What does that mean? Well, I've got an example here of a dark red rose. So let's say that you are a plant breeder and you've just developed a new variety of rose, which is producing particularly dark red flowers. Now, if you wanted to register a trademark for that rose, if you were to apply for the words dark red rose, chances are your application would be rejected because the words dark red rose are descriptive of the goods. They're not going to tell the public where the goods came from. It tells them what they are. It's not an inherently adapted to distinguish mark, right? On the contrary, if you were to apply for XYZ123, that has absolutely nothing to do with roses, right? That mark is inherently adapted to distinguish roses. Okay, it's akin to the Apple symbol for computers, right? Apples have nothing to do with computers, so the Apple symbol is inherently adapted to distinguish computers. The final comment I want to make about trademarks is their lifetime. Unlike other forms of registered IP, trademarks can last forever as long as you pay maintenance fees. So once you've got a registered mark, you will have to pay maintenance fees, but as long as you pay those maintenance fees, that trademark is yours forever. Okay, I mean, think about how old some of these are. The Coca-Cola one has been around for however long. McDonald's Golden Arches, they've been around since forever. So trademarks, once you register it, it belongs to you as long as you pay the maintenance fees. This slide is just to show how you can have many marks on a single product. I mean, whether or not these are actually registered, you can see that potentially you could register the words, the logos, the color, the shape potentially. These could all be potentially registered as trademarks, and they would distinguish these particular goods from others. I mean, if you see these colors and this shape and this writing, you know that this is a Corona beer, and you can distinguish it easily from, let's say, a VB, right, which is a short, stumpy thing. Okay, so that's all I'm going to say about trademarks. Next, I want to talk about plant breeders' rights, and we'll cover this fairly briefly as well. What are plant breeders' rights? Well, they are exclusive rights to exploit a particular plant variety. They're limited to a single plant variety, and they provide exclusive rights to produce or reproduce propagating material of that variety, among other things, sell or offer to sell propagating material from that variety, and so on. And the exclusive rights conferred by the plant breeders' rights, or the PBR, last for 20 years or 25 years, depending on which plant we're talking about. 25 years in the case of trees and vines, like grapevines, plants which take longer to grow, essentially. If we're dealing with roses or cabbages or lettuce, then it's a 20-year term. So what are the requirements for obtaining plant breeders' rights? It must have a breeder. What that means is you can't just walk out into the forest, collect an interesting looking plant and obtain PBR for it. Right? You have to have actually bred a new variety. The variety must not have been exploited or only recently exploited. So what that means is you can't have been selling your plant on the market for the past 10 years and then decide, I want to file a plant breeders' rights for it. It's no longer new. It's too late. Your variety has been exploited. So ideally, what you want to do is, as soon as you've developed a new variety, file a PBR application for it, and then go ahead and start commercializing it. And then the final three here are the so-called DUS requirements: distinct, uniform, and stable. Now, what that means is, first of all, distinct. Your variety has to be unique. It has to be different from all the other varieties that are commonly known. On top of that, it has to be uniform. So all of its brothers and sisters have to look the same. and it has to be stable, which means from generation to generation, the variety has to look the same. It can't change over time. Your dark red rose, you can't get to the next generation and find that it's sort of a slightly pink rose, and then the next generation and it's a white rose. It has to maintain that same phenotype, that dark red phenotype, from generation to generation. And this is the so-called DUS requirement. Now, there are a few limitations on plant breeders' rights. The first one being that you'll see from the earlier slide that the exclusive rights conferred by plant breeders' rights primarily relate to the propagating material of a single plant variety. Okay, so going back to the rose example, the protection doesn't. The PBR wouldn't provide protection for any variety of dark red rose, only the variety that you have made, right? The dark red rose variety that you have bred. And the protection relates primarily to the propagating material of that rose. Another limitation is the so-called breeder's exemption. What that means is PBR doesn't provide protection against a third party using your variety in their own breeding program. Right? So they could potentially use your variety to breed a new variety without infringing your PBR. And the final limitation there is the so-called farm-saved seed exemption. What that means is a farmer can and should pay for seed that you have got PBR protection on. They can sow the seed on their land, grow the plants, but then what they can do is take the seed from those plants and sow a new crop without infringing your PBR. That's the so-called farm-saved seed exemption. And these are big limitations on plant breeders' rights. And so, at least when it comes to protecting plants, that's what renders plant breeders' rights narrower than a patent, which is what we'll discuss next. So what is a patent? A patent is a quid pro quo. It provides you with for a limited period, it provides you with monopoly to an invention, but in exchange, you have to disclose to the public what your invention is and how they can perform your invention. So that's the quid pro quo, that's the exchange. It'll give you exclusive rights. In exchange, you have to publicly disclose your invention. So why would you want to file a patent for a new invention? Well, there's many reasons, and you're probably very familiar with them. It allows you to capture and defend a market. So if you've developed a new invention which is commercially valuable and you don't want others stealing and copying your idea, patents provide you with a legal form of protection against that. It can also attract investors. If you have developed some proof of concept data for a therapeutic and you need funding to take that to the next stage, potentially to clinical trials, and you need some external funding, maybe some venture capital. A venture capitalist, for example, will want to see that you've got some sort of formal IP protection around your technology before they invest. So a patent can be attractive to investors. Patents can also create revenue streams. You might have a patent for a technology which you yourself don't want to use or cannot use because you don't have the resources. In those circumstances, you might license your patent to a third party who does have the resources to exploit that technology and commercialize the technology. And in exchange, that company might provide you with a percentage of their sales as a form of royalty. Patents can also boost company value. In a lot of cases, you know, they are the fundamental value of a company. In the case of, you know, a small biotech company that's working on one or two lead compounds for treating a particular disease, those compounds might be the subject of a patent, and that is the core of the company. The company itself is built around that patent. A lot of pharmaceutical companies, even the big ones, it's their IP which provides their value, and so that IP must be well protected. So patents can boost a company's value. And patents can also incentivize R&D, and this is sort of a fundamental purpose of patents. You can imagine if you do have that proof of concept data for a new therapeutic, and you want to take it to market. In order to do so, you're going to have to get a lot more data. You're going to have to go through clinical trials, which could take, more than 10 years, could cost millions, if not billions of dollars. And at any point along that path, it could fall over, it could fail. So it's a high risk, very expensive process. Now, if you're going to spend millions and millions of dollars and years of time, you really want to make sure you can recoup your costs and exceed those costs at the end if you are successful. For every 5 projects that you engage, maybe only one is successful. So not only do you want to recoup the costs of that one, but you want to make up for the other 4 that failed as well. So it's very high risk and very expensive. What a patent provides you with is certainty that at the end, if you are successful, you will have exclusive rights to commercialize the technology. Without the patent, you could go through all the clinical trials, do all the further research and development, and then other companies could just pick up the technology and commercialize it themselves and dilute your market share, and you won't recoup your costs. So in the absence of a patent, a company just wouldn't embark on that journey. They wouldn't take that risk. Patents provide the incentive to head down that path. Okay, everything you need to know about patents in one slide. The term of a patent is 20 years in most cases. I put an asterisk there because certain pharmaceutical patents can be extended by up to 5 years, but generally speaking, the term of most patents is 20 years from the date of filing. The requirements to obtain a patent are, there are many, but these are the main ones. It must be novel and inventive. What that means is compared to everything that was known before the time that you filed your patent application, the invention must be new, it must be novel, and it must be inventive. So if it's not quite identical to something that was already known previously, but it's kind of just an obvious extension, then it may not be inventive. It has to have what's called an inventive step. The invention must be useful. What that means is it must work, it must function, right? You can't patent a perpetual motion machine. There's no such thing, it won't work. And you must provide in the patent specification an adequate disclosure of your invention. So that goes back to the quid pro quo of a patent. In exchange for the exclusive rights, you need to disclose to the public what your invention is and how it can be performed. And there are rules around how much disclosure you must provide in a patent specification, and we'll go into that a little bit later. The subject matter of a patent, so what can you patent? You can patent compositions, so things, physical objects. You can patent methods, methods of doing something, and processes for doing something. Chemicals, in some cases you can patent organisms themselves, and the list goes on. Certain things that you can't patent, however, human beings, artistic creations, mathematical models. E equals mc squared could not be patented, nor could you or I as human beings. But the list of things that can be patented is very lengthy. Okay, so the requirements for patenting. As I said, the invention must be novel and it must have an inventive step. And that's relative to what's called the prior art. Prior art includes all information that was publicly available before the priority date. Now, the priority date is the date when you first file a patent application, right? So that's why it's important to file a patent application as soon as possible, as soon as appropriate. That puts a stake in the ground, and that sets your priority date. Everything that was known before then is prior art and will be used when assessing the novelty and inventive step of your invention. Now, I've got in brackets there a reference to the grace period. I don't want to highlight that too much because it's really just a fallback position. It shouldn't be thought of as a strategy. What the grace period is, it refers to if you disclose your own invention. Let's say you go to a conference and speak about your invention. There is still the potential to file a patent application if you do so, at least in Australia, within 12 months of making that public disclosure. Okay, that's the so-called grace period. Now, it's not something you want to rely on because certain countries, not all countries, provide a grace period, and the countries that do have different grace periods. You know, that it relates to specific types of disclosures. The actual period might differ, whether it's 6 months or 12 months, and yeah, as I say, some very important jurisdictions from a commercial perspective don't offer a grace period. So it is available, it's there, but it shouldn't be thought of as a strategy, a filing strategy. Now, when it comes to the prior art itself, it can take any number of forms. It could be a scientific journal, it could be an earlier patent application, it could be a conference abstract or a conference presentation. If you publicly used your invention before filing a patent application, that public use could be thought of as prior art. So the list would go on and on. So when searching for prior art, usually that's done by a patent office, a patent examiner in a patent office. They could search all sorts of resources. So PubMed would be one where you'd find journals, for example. I've listed here various patent databases. These are all publicly available and freely searchable. So IP Australia is the Australian patent database. There's Google Patents. There's the US patent database, the World Intellectual Property Organization database, the European Patent Office database. There's a website called Free Patents Online. I like using that one. And of course, when searching prior art, you can just Google. Google will search all sorts of resources, obviously. Okay, now turning to the subject matter of a patent. So I listed before some of the things that you could patent. Here's one example of a mechanical device that might be the subject of a patent. I've shown here a can opener, but of course, any sort of mechanical device could be the subject of a patent. Potentially, you know, looking at this can opener, this might be, you know, a 3rd or 4th generation can opener. I don't know. There may have been a more primitive can opener that was the subject of a patent, which was subsequently improved, and each version was the subject of its own patent. But the point to make is that devices, physical objects, can be patented. Small molecules, you know, a pharmaceutical compound, for example, can be patented. This chicken wire looking thing could be the subject of a patent. And large molecules could be the subject of a patent. So an antibody in this case, or, you know, a therapeutic protein, or these could be the subject of a patent. Methods of doing something can be patented. Now I might sit on this slide for a little bit because this may be relevant to your own situation. Why might you want to patent a method of treatment, for example? Now, let's say you've taken a drug which is known, a pre-existing drug, but you've applied it in a therapeutic indication which had not been thought of previously. Maybe you've taken a drug which is known to treat cancer, and you found that it treats COVID-19, right? Now that drug itself is known, so you can't patent it, it's no longer novel, but no one has ever thought of using it to treat COVID-19. So that may be the subject of a patent. You might have a patent which claims a method of treating COVID-19 using that drug. So that method could be the subject of a patent. And in Australia, at least, methods of medical treatment are patentable, as they are also in the United States. some jurisdictions like New Zealand and Europe don't allow methods of medical treatment, but there are ways around that. But the point is that methods can be patented and can be quite valuable too. You could imagine, a drug for treating COVID-19 right now would be very valuable. Organisms can be patented. If you've engineered a bacteria to degrade plastic, you could patent that microorganism. And genes, DNA, I've put a question mark here because the answer is not black and white. If you had asked me 10 years ago, then the answer would have been yes, you can patent genes, isolated genes. But now it's not so clear cut, thanks to this lady. Her name's Yvonne Darcy. She challenged a patent for the BRCA1, BRCA2 genes, which are associated with breast cancer, diagnosing breast cancer. And she made quite a few headlines in doing so. So the patent that she was challenging was owned by Myriad Genetics, and it claimed isolated nucleic acids, which were polymorphic versions of the BRCA1, BRCA2 gene, and could be used to diagnose susceptibility to breast cancer. Now, she challenged the validity of those patents in the federal court and was unsuccessful. The federal court said, no, you can patent these genes. She appealed to the full federal court. The full federal court also said that you can patent isolated nucleic acids. She appealed then all the way to the top to the High Court, and the High Court overturned the full court's decision and said, no, the claims are invalid. You cannot patent isolated naturally occurring nucleic acids. Now, the reasoning behind the High Court's decision still leaves room for patenting certain nucleic acids. So what the High Court said was that the patent in question was claiming an isolated version of a naturally occurring gene, right? And the High Court considered that to just be, in effect, in substance, it was information, naturally occurring information, which had not been created by a human being, and therefore could not be the subject of a valid patent. Now, what that means is if you had engineered a gene, let's say you'd, codon optimized a gene, or you'd, engineered it to remove a particular domain and stitched it back together, that arguably is not naturally occurring anymore. It's not naturally occurring information and could be the subject of a valid patent. So the answer to can you patent nucleic acids is yes, in certain circumstances. Okay, what does a patent look like? They generally follow a similar structure. There'll be a title, there'll be an abstract, a description of the invention. This can be very lengthy. There will be examples, typically, which is not unlike the materials and methods and results section of a journal article. Then towards the end of the patent is the business end, the claims. The claims are a series of individual sentences which define the scope of the monopoly. Right? And we'll take a look at what a patent looks like. If I can find one. So here's one that I've just pulled up using the Australian Patent Office database, AusPat. If you just Google AusPat, you'll find it. It should be your first hit. You type in your queries using either a quick search, or you can do a structured search if you want to search for the title of the invention, the applicant name, so the owner of a patent, and so forth. But here's a method of treating cancer. You can see the patent is 79 pages, which is actually probably fairly short for this type of technology. You can have patents that go on for hundreds of pages. But you can see there's background of the invention, which is kind of like the introduction of a journal article, brief summary of the invention, description of the drawings. It's like the figure captions at the back of the specification. You'll see that there's a series of drawings. Then there's the detailed description of the invention. So this is describing what the invention is and how it can be performed. And this will stretch for dozens of pages. So if we get through all of that, somewhere towards, well, there's the drawings. I'll skip to the end. That's the drawings, which are always found at the end. Now, as I said, there's going to be some examples. So this is where they actually describe experiments that they have conducted and the data. And so that'll refer to the drawings at the end. And then the business end, these are the claims. So you'll see each claim is a single sentence and it defines what the invention is. And anybody who performs a method which falls within the scope of this claim will be potentially infringing of the patent. Now, to be technical, this is not actually a patent at this point. This is a patent application, which means somebody has applied for a patent. What's going to happen is this is going to be prosecuted in the patent office, where an examiner is going to assess whether or not these claims are novel, whether they're inventive, whether they're useful, and so forth. And during that process, the scope of these claims could be narrowed. The scope could change, and the final form that they take may be slightly different to how they look now. But the point to make is you can see at the back of the patent specification is these series of claims, and each claim defines the invention. Claim 1 is typically, not always, but typically the broadest claim, and they will progressively narrow. So that's what a patent specification looks like. Okay, so how do you apply a patent in practice? Now I'm going to return to the plant example here, just so that you can, it also allows you to compare the power of a patent compared to something like a plant breeder's rights, which we discussed earlier. So let's say you've bred a new plant variety, which I've put in a box here. Now, if you were to obtain plant breeder's rights for it, you would have protection just for that single variety itself, and that's it. Now, with a patent, what I might do is I might claim that variety. Okay, I could potentially even claim more broadly. I could say a plant which has a particular phenotype. So it's not strictly limited to a particular variety, but a plant which has any phenotype that resembles it. So that would be my claim 1. But what if somebody were to just take and sell a part of the plant, so maybe just a leaf? Arguably, they're not infringing my patent anymore because they're not taking the whole plant. My claim 1 defines a plant, not a leaf. So therefore, I'll stick in another claim, which says a leaf of the plant or a part of the plant. And now I've got that potential infringer covered. A third claim might be to nucleic acids. Let's say I have genetically modified my plant to express an engineered protein which confers resistance to a particular fungus. That nucleic acid molecule, if it's not naturally occurring, may be the subject of a third claim. A fourth claim might be a method claim. It might be a method of using my plant in a breeding program to cross my plant to another plant, let's say. Now, the point of this claim is to highlight another distinction from plant breeders' rights, where there is that so-called breeder's exemption. This claim 4 annihilates that breeder's exemption, right? It directly targets anyone who wants to use my plant in a breeding program. A fifth claim might be a method of generating my plant. If I know what the parents of my plant are, I could potentially claim a method of producing my plant by crossing those parents. And I could potentially claim the progeny of my plant, and on it goes. So you can see that with just 6 claims, I've really built a fortress of protection around this one plant variety. No one can come near this plant variety without potentially infringing my patent. And that's the power of a patent. Okay, some of the strategic considerations when protecting your IP. I won't go through all of these. Some of them I'll go into more detail later on. Some of the important ones, being aware of the direction of your research, and if you can map out your research, years into the future, then you can develop an IP protection strategy around it. You won't necessarily have to try and capture everything that you plan to do in one patent. You could potentially stagger your filings over years to strategically protect your research, or the products of your research in a robust manner over time. Being aware of IP. This is often limiting in universities, in academia, where academics will often live by the motto of publish or perish, where public dissemination of knowledge is the be all and end all. That's that rubs up against IP protection, where confidentiality is often required. So being aware that if you've got a new discovery in the lab, before you go off and tell everyone, think, is this something that's commercially valuable and could be protected by a patent first? So that's the point of confidentiality as well, but not with your patent attorney. I often come across inventors who don't want to give away all the secrets of their invention, even with their patent attorney, but that's not going to work, because the patent attorney needs to know the best way of performing your invention in order to provide robust protection for it. Strategic fit. You might come up with, you might stumble across something exciting in the lab, which could be the subject of a patent, but it really is of no interest to your commercial endeavors. It's sort of just a side gig. At that point, you might want to ask, is it really worth the time and expense of seeking a patent for something which I really am not interested in, even if I could patent it? Issues of ownership. This often comes up in universities. Essentially, the owner of a patent is ultimately dictated by who the inventors are. So let's say you've got two universities that have collaborated on a project. So you might have UTS has collaborated with Monash, and you've got inventors from each university. Well, if those inventors have assigned their rights to the university by way of their contract of employment, and this is very often the case, then the inventors will be, the academics, let's say. The owners of ultimately the owners of the patent will be each university. So you'll have two owners, Monash and UTS. Having co-owners like that can complicate commercialization. Often investors or commercial partners will want to see, a single owner, and that can be dealt with. You can assign rights to a single entity. But the point to make is that ownership ultimately stems from inventorship. This is one reason why it's important to keep, good lab records, to know who's done what. Inventorship is not the same as authorship on a publication. It's a different legal test. But it's important to know who's done what in the conception of an invention. The final points there, I'll go into more detail in subsequent slides. Okay, so when to file a patent? I said earlier that there's good reason to file as soon as possible, to set that priority date as early as possible, because that's the date upon which all what is considered prior art will be searched. So everything that was, all public disclosures that were made before your priority date will be relevant to the novelty and inventiveness of your invention. Right, so you want to file that first patent application as soon as possible. However, there is a requirement under Australian law that each claim of your patent has to be sufficiently enabled, it has to be supported by what's disclosed in the patent specification. So if the claims of your patent application are extremely broad, you want to have a very broad monopoly, well then that's all very well. However, you're going to have to disclose you're going to have to disclose in the patent specification a way of performing that invention across the full scope of the claim. So one of the legal tests is that the patent specification should provide sufficient information to enable an ordinary skilled person to perform the invention across the full scope of the claims without undue burden or the need for further invention, right? Put simply, if you want to claim broad, you're going to have to provide a lot of disclosure to support those claims, right? So in practice, what that means is if you've got a very rough result in the lab, a quick proof of concept, a good result, and you want to rush to file a patent application, your patent attorney might advise that, yeah, you could potentially obtain a patent, but the scope of the claims that you could obtain on the back of that data is quite narrow. You know, the patent attorney might say, get back in the lab, get a little bit more data, not much, just a little bit more, and you could potentially double the scope of your claim, right? And have a much more valuable patent at the end of the day. So there is that balance to strike between filing as early as possible, but doing so with the right amount of data. Okay, so this is just to show you in a diagrammatic form this concept of support. So let's say I have developed here an antibody, a single antibody, which binds to protein X, right? So I've developed one antibody which binds to a known protein, which I'm calling protein X. Now, in my patent, I might claim a molecule that binds to protein X. And the circle here is just to indicate the scope of that claim. It's a big circle, it's a broad claim, right? Now, have I generated a molecule that binds to protein X? Well, yeah, but not really that broadly. I haven't created a small organic molecule or some small protein fragment. I've created one antibody. So the word molecule there is probably too broad given the data that I've obtained. All I've obtained is one antibody, not a whole plethora of molecules. So I may have to narrow my claim. Okay, so now my claim is narrower and it defines an antibody that binds to protein X. So now anybody who produces an antibody which binds to protein X would infringe that claim. Now that might seem more aligned with what I've developed, but still that could be too broad because I haven't really developed, any antibody that binds to protein X. I've developed a single antibody that binds to protein X, right? So really, should I be entitled to a claim which would prevent somebody from developing a different antibody which binds elsewhere on protein X? That's an argument between the attorney and the patent office, but possibly that's too broad. So I might have to narrow the claim even further. Now I've got an antibody which comprises a specific amino acid sequence. So in this claim, it's much narrower, and I am just claiming the single antibody that I have produced. Right? So I would define my antibody with reference to its amino acid sequence. So this is the point. If I had developed, let's say 10 antibodies, 10 different antibodies, and they all bind to protein X in different places, and there's sort of this general principle of how to develop antibodies that bind to protein X, well, then maybe I'll be entitled to a broader claim. I could be entitled to an antibody that binds to protein X. So now anyone who produces any antibody binding to protein X would infringe my claim. So this is where the balance must be struck between filing as early as possible, but getting as much data as you can to support a commercially valuable claim. Okay, timing and costs. Now this is probably the most complicated and boring slide in the presentation, but I want to pause on it for a while because it has got some important information. You can ignore most of the detail on this slide. The stars here are sort of the important deadlines. The first one is time point 0. This is when you first file your patent application and set your priority date. Now, typically, the first application that you file is what's called a provisional application. Not always, but typically it's a provisional application. And what you do when you file that first application is you've just set in train all of these deadlines for years to come. Now, this is actually months, but it lasts for years. Now, the first deadline after filing that priority date is 12 months down the track. That's your PCT filing deadline. Now, PCT is short for Patent Cooperation Treaty. This is a treaty among most industrialized nations in the world, and it's sort of this it can be thought of as a patent application in all of these major jurisdictions, all bundled up into one. Now, there's no such thing as a global patent. If you want patent protection in multiple countries, you're going to have to file separate patent applications in each of those countries. But what this PCT application does is it sort of preserves your right to file separate applications in different jurisdictions at a later date. So from a practical point of view, the specification itself that you file at this point could look identical to the provisional. You could just refile it as a provisional, you could refile it as a PCT application. You may add some more data, you may not, it may be identical. Point is, it must be done 12 months from filing your first application, which is typically that provisional application. Now, the next deadline I want to highlight is the 18-month deadline. This is 18 months from the day that you first filed your patent application. At that point, your patent application is published. Now, why is that important? Well, let's say 10 months after filing your provisional application, you've changed your mind and you want to get some more data, refile the application with broader claims. What you can do then is withdraw your patent application 10 months down the track and refile it and start the clock all over again. And that whole time, your invention, or at least the patent application, has not been publicly available. For the first 18 months, it remains confidential in effect, right? After 18 months, it's published. So after 18 months, if you've changed your mind and you want to refile your patent application, well, it's kind of too late because your invention has now been published. It is now publicly available. Now, the final deadline I want to talk about is this one at 30 months. This is the so-called national phase entry deadline. Now, the actual deadline can vary between jurisdictions. It can be 30 or 31 or 32 or different. But in most jurisdictions, or in many jurisdictions, it's 30 months from this priority date. That's the deadline by which you have to unbundle that PCT application. You'll recall I referred to that as a patent application in all the different jurisdictions, all bundled up into one. 30 months down the track from filing your provisional application, you have to unbundle it and file separate applications in each jurisdiction in which you want protection. Right. So if you want to file a patent application in the US, you're going to have to file a US national phase application. In Europe, you're going to have to file a European regional phase application. In Australia, an Australian national phase application, and so on. Now, if you don't file, let's say, a Japanese national phase application and the deadline passes, well, then you no longer can file a patent application in Japan. The deadline has now expired. So it's sort of at this 30-month point, it's decision time in terms of which jurisdictions you want protection. Now, why is this important? Well, the first point to make is it's expensive, right? Once you hit that national phase deadline, if you file a patent application in the United States, that has its own set of costs. You file a patent application in Australia, that also has its own set of costs. There's no economy of scale here. For each jurisdiction that you file a patent application in, the costs are additive, right? So you want to be selective with where you file your patent application. So in this case, this is a great Aussie invention. This is an esky with cricket stumps as a handle. Brilliant idea, but probably a very limited number of markets, right? So you can probably guess the major jurisdictions where they've sought patent protection for this invention. Those being the big cricket playing nations which have hot weather, right? So Australia, New Zealand, South Africa, UK, and India. Not surprisingly, they haven't filed a patent application in Norway or Sweden, where they have neither cricket nor warm weather. So this is an example of a filing strategy which is jurisdiction specific. So the main factors to take into account are the market, how big is the market for your technology, and what are the costs are going to be to obtain patent protection in that particular jurisdiction, and do a sort of a cost-benefit analysis there. There's other factors to consider which are more nuanced, such as how enforceable is your patent in that jurisdiction, and so forth, and the scope of protection that you might obtain under local laws, because each jurisdiction has its own patent laws. But really, it's sort of weighing up the costs and the benefits and the risks. If you're dealing with a big blockbuster drug, if you've got a vaccine for COVID-19 right now, you would be filing in most countries all around the world. I imagine the market is big everywhere. But on the other hand, if you've got a cricket stump esky, well, then the market is more limited. Okay, for the final part of this talk, I'm going to switch gears for about 10 or so minutes, and we'll be on the other side of the table. We're now no longer necessarily the patentee, but we're a third party that wants to exploit an invention. Now, this is something that often slips people up a little bit. Just because you've filed a patent application for your invention, and you may have even obtained a patent for your invention, doesn't necessarily give you the right to exploit it. Okay? And what that means is, take the method of treatment example I gave earlier. Let's say you've taken a known drug, which was known to treat cancer, and now you're using it to treat COVID-19, right? And you filed a patent application for that method of treatment, a method of treating COVID-19 comprising administering this drug. Now, the drug is known, and the drug itself might be the subject of a patent that was filed 10 years ago, right? Now, that patent won't necessarily prevent you from obtaining your own patent, a more limited patent to the method of treating COVID-19, but that patent still exists, right? So to exploit my own invention of treating COVID-19, I would be infringing that earlier patent, right? Now, a third party who wants to exploit my invention, so they want to use the drug to treat COVID-19, that person would arguably infringe my patent and the earlier patent. So they'd be infringing two patents. Okay. So the bottom line there is that having a patent does not necessarily give you freedom to operate. One of the problems, or one thing to look out for is so-called platform technologies. CRISPR, genome editing, is a good example. So like 7 or 8 years ago or so, CRISPR was the big thing, right? It sort of burst onto the stage, and at the time, some foundational patent applications were filed for the fundamental use of CRISPR to edit DNA. So those patents exist. Now, almost a decade later, people are finding more niche, more nuanced uses for CRISPR for treating particular conditions and disorders using that technology, and they're filing patent applications for those more niche applications. Now, to exploit those niche applications, you have to rely on those platform technologies which are already patented, right? And as time goes on, people will find further and further uses of that technology and file patent applications for it, such that you develop this patent thicket around the technology. And they're all sort of based on this platform. So that's something to watch out for. And I've tried to indicate it here with a rather confusing Venn diagram. Whether or not it helps or complicates things, I'm not sure. But let's say here we've got a series of patents, each circle here representing a patent of a particular scope. We've got 3 different patent owners represented by different colors. Each owner has filed a different number of patents. So in brown here, we've got one company that has filed 3 patents, so 1, 2, 3. In pink, we've got another company which has filed 1, 2, 3, 4, 5 patents. And then in violet, we've got a company which has filed 3 patents. Now, what you can see here is that patents can overlap in scope, right? So think of the method of treatment that I described earlier. The two patents in that circumstance would overlap in scope. This big circle and this big brown one here is potentially a platform technology which has been patented, and it's supported all of these other enabled, it has enabled all of these other technologies to be built upon it. Now, let's say I come along with my own great idea and I want to patent it. Here's my idea. It's represented as a dotted line. Now, this is the scope of my technology, and I want to file a patent for it, and I may very well obtain a patent for it. But in performing my own invention, I may infringe any one of 4 different patents owned by 2 different parties. So in those circumstances, if I obtain that patent, what are my options? Well, the first option would be to work around it. So find out which patents you are likely to infringe, and then amend your own technology. So sort of rejig your own technology to work around those third-party patents so that you no longer infringe them. Now, in some cases, that might not be practicable or even possible. So another option would be to license the third-party technology. So the company that owns the patent that you're likely to infringe, you could approach them and say, you can seek a license from that company, and in exchange, you pay them, for example, a percentage of your sales as a royalty. A third option would be to purchase the patent. So if you come across a patent that you're likely to infringe, perhaps the company that owns that patent has no use for it. They're no longer using it. You could potentially approach that company and say, look, I can see you're not using this patent. I'd very much like to. Can I buy it from you? And they, if so, then they can assign that patent to you. Now, if those options are not available or practicable, then another resort would be to just challenge the validity of the patent. So this is not uncommon in the pharmaceutical industry. You could take the patent owner to court and say that their patent is invalid. It should never have been allowed. Perhaps you find prior art that that you could argue renders the patent lacking novelty or an inventive step, for example, and so you can litigate. And this is just, this diagram is just to show how a license works. So here we've got 2 companies. Company on the left here licenses the company on the right to use its patented technology, and in exchange, this company provides royalties of some description to the patent owner. An alternative arrangement is a so-called cross-license. So what if each company has a patent that the other one wants to use? You could potentially come up with a deal where, I can use yours if you can use mine. That's sort of what a cross-license looks like. Okay, well, that is all I had to say on intellectual property. If you made it to the end of this presentation, congratulations, and thank you for listening.